we have to cover Hunter Biden's motion to dismiss his indictment in the United States District Court for the District of Delaware arising from gun-related charges because Hunter Biden is using, as I predicted on Fox News, the Second Amendment to get out of this. Will it work? And what is he arguing? And how could his motion have been improved? We're going to touch base with all of those things when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee in two separate categories for the 2024 Gundy Awards, Top Male Influencer, and also Top Voices of the Second Amendment. I am honored to be nominated in both categories. All right, so Hunter Biden has been indicted by the United States Department of Justice after much pressure on the prosecutor there. And he's been indicted for a gun-related charge for taking possession of a firearm and filling out a Form 4473 while he was under the influence of, or I should say while he was using illegal substances. That's the charge. And thus, this allegedly is a violation of 18 U.S.C. 922G3, which provides that you are not allowed to possess a firearm if you are an unlawful user of or addicted to a controlled substance, as that is defined by federal law. The charge is that Hunter Biden was using controlled substances illegally while he acquired a handgun and filled out a form, a 4473 form, where he indicated he was not an unlawful user or addicted to any of these controlled substances. Now, he has just filed a motion to dismiss the indictment for failure to charge a constitutionally permissible offense. And he relies extensively on Heller and Bruin to argue that under American history, occasional users of controlled substances cannot be deprived the right to keep and bear arms, and that under the Bruin methodology, which is really the Heller methodology, of look at the text of the Second Amendment first, shift the burden to the government, and then again, if the government bears the burden to come forth with a long-standing historical laws going back to our founding, showing that whatever the gun control law is they're trying to enforce today in 2023, that this law has its sort of inception in concept going back to the founding of the country, that the founding fathers would consider this kind of a modern day law to be consistent with what the Second Amendment means. Now, the lawyers for Hunter Biden have done a pretty good job. I'll put a link to their brief down below. They rely on two major things, and there's one thing I think they could have relied on and they should have relied on, but they didn't. We'll talk about that in 1 second. To begin with, they really argue that 18 U.S.C. 922G3 is unconstitutional, and in doing so, they cite to the United States Court of Appeals decision of United States versus Daniels out of the Fifth Circuit, which is Louisiana and Texas, that says there simply is no historical tradition of firearms regulation that says that if you are a user of a controlled substance or even a user of, let's say, alcohol, that is not a basis to disarm you. There might be some precedent that says that if you are using alcohol or a controlled substance or impaired, that you cannot have a gun at that moment in time. There may be an argument along those lines, but what the Fifth Circuit said is, regardless of how you interpret those precedents involving, you can't have guns while you're intoxicated walking down the street, whatever that means, it certainly doesn't mean that if you're an occasional or user of these substances and you're not actually under the influence at the time you possess the gun, there's no historical tradition for that. Keep it in mind that, of course, our founding fathers often went to taverns and plotted and planned for the American Revolution and our freedom from Great Britain in taverns, such as, for example, Francis Tavern in New York City, and the taverns where Sam Adams would serve his brews in Boston. So a long-standing tradition of people being where there's alcohol served with firearms. And again, that is exactly what the Fifth Circuit in the United States versus Daniels case said. Then Hunter Biden's lawyers went on to say that in addition to that, if you look at the U.S. Court of Appeals for the Third Circuit, which is the relevant circuit here because the Third Circuit covers Delaware, New Jersey, and Pennsylvania, in the Range case dealing with a different prohibited person, in that case 18 U.S.C. 922 G1, that says you can't be a felon in possession of a firearm. In the range case, they specifically said that the touchstone for a prohibited person under 922 G1 is that you are violently dangerous. The issue is, are you dangerous in a physically violent way? And that is really the touch point as to whether or not you can be disarmed under American historical laws. And of course, that is cited by Hunter Biden's lawyers here, to say that's further evidence, among other things, that basically Hunter Biden was never been viewed as dangerous in a physically violent way, and therefore yet further proof that the United States Court of Appeals for the Third Circuit, which governs the District of Delaware where this case is pending of Hunter Biden's, that the Third Circuit would embrace the views of United States versus Daniels out of the Fifth Circuit. So I think all those arguments are good. And then furthermore, and we've talked about this on this channel before, to the extent that 18 U.S.C. 922 G3, that says, again, you cannot possess a firearm if you're an unlawful user or addicted to a controlled substance, to the extent that's unconstitutional, then questions about that standard, or questions about that criterion, would be irrelevant and immaterial, and thus, to the extent they've charged Hunter Biden, which they have here, for making false statements that are material in nature about his ability to acquire a handgun on those 4473 forms, it means those questions are no longer relevant or material to anything that speaks to his ability to have a gun or his right to have a gun, and therefore the charges against him for not just being a person that's in possession of a firearm while as an unlawful user or addicted to these substances, beyond that, his statements about this are simply irrelevant, and thus he cannot be charged for making a false statement or lying on that 4473 form, or on the related note of lying on the form and causing someone to hold a document that contains a falsehood in their bound book or in their files at an FFL shop, which is also another charge here. So the bottom line, I think this is a pretty good motion. Now, where I think that the lawyers for Hunter Biden could have improved is they seem to have not noticed or decided not to cite to the fact that the judge involved in the United States versus Hunter Biden case is Judge Mary Ellen Noreika. Now, the reason why this is important is Judge Noreika, you've heard before on this channel, long before she got involved and basically helped wipe out the Hunter Biden plea deal by asking a series of questions. But you know Judge Noreika from this channel because she is the one in the case of Rigby versus Jennings that declared that Delaware's quote-unquote ghost gun ban was unconstitutional under the Second Amendment. And the one thing I might have done if I was working on this brief for Hunter Biden is I probably would have reminded the judge that she herself has already ruled in favor of the Second Amendment and knocked out laws because of a lack of historical tradition. And I think what I would have done is I would have referenced that Judge Noreika, the same judge involved in this case, had, quoted Bruen, relied on Bruen in knocking out Delaware's quote-unquote ghost gun law, at least on a preliminary injunction basis. And I would argue that basically the same analysis that she used in that Rigby versus Jennings lawsuit, she could use here in the Hunter Biden case. And I probably would have reminded her that she's already handled Second Amendment-related cases and come out favorably, and that she should do so here in favor of my client, Hunter Biden. That's what I would probably be arguing. In addition to the things they said here, I would probably have reminded the judge that she had already ruled favorably for the Second Amendment and knocked out laws based on the Second Amendment, and therefore it's not unusual for her to do it here in the case of Hunter Biden. But other than that, I thought that their brief was pretty good. They made all the relevant arguments, and then the question is, what is going to happen with Judge Noreika? I'll let you know what the government argues when they file their opposition brief as to why they think 18 U.S.C. 922 G3 is constitutional, and then we'll analyze that once that is submitted. Again, the U.S. Supreme Court has actually got a case in front of them pending cert. They haven't granted cert yet. We'll see if they do, and that is the United States versus Daniels case. And as I told you before, one of the things that may be happening in the United States versus Range case dealing with 922 G1 felon in possessions, which is also up on potential cert, is that they may be waiting for January 5th, because January 5th they're going to conference the Daniels case, and it may be the case that the Supreme Court discusses whether or not they're going to hear the Daniels case dealing with 922G3 and or the Range case dealing with 922G1, in addition, of course, to the argument they've already heard in the Rahimi case dealing with 922G8, domestic violent restraining orders. So the question is, on January 5th, will the Supreme Court decide to take all of these cases and handle them all kind of as a gestalt this term, or are they going to wait for the Rahimi case to issue and then decide what they're going to do with the U.S. versus Daniels case, which would speak to the Hunter Biden issue of 922G3 and or the Range case dealing with 922G1? Only time will tell. But in the meantime, I'll keep you informed as Hunter Biden continues to prosecute on our behalf, really, as Americans, his Second Amendment rights, and it'll be interesting to see how this all plays out. And of course, I'm not going to mention the hypocrisy of his father being the chief anti-gun lobbyist in America in all respects and the worst gun president in American history, while his son's out there trying to vindicate his Second Amendment rights. I'll leave the hypocrisy for you guys to comment in other venues. So, all right. Well, we'll talk to you soon here at the Four Boxes Diner. I hope you learned something. Don't forget to subscribe and follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.